When the European arrest warrant was proposed and steered through the European Parliament by a British Liberal Democrat MEP, it was already obvious then that a clear consequence of the European arrest warrant would be that British citizens and residents, and for that matter citizens and residents of other member states, will be carted off to countries where conditions in prison are of a lesser standard. That was totally obvious.
Since 2004, I have warned that the European arrest warrant could be used as an instrument of oppression against political dissidents. This is what is happening now in the case of Julian Assange.
Ever since Mr. Assange requested diplomatic asylum, we have held in-depth talks with the United Kingdom, Sweden and the United States, and we have appealed to receive guarantees from the United Kingdom, strictest guarantees, so that Mr. Assange could face without obstacles the judicial process in Sweden, so that once those issues in Sweden were dealt with, that he would not be extradited to a third country. That's what we have been seeking in Ecuador. Sadly, and despite our repeated attempts, the United Kingdom at no moment accepted or showed any willingness to negotiate on that issue.
Given our need to fulfill our obligations under international law to deliver a suspect for questioning on serious offences, we have ensured that the Ecuadorian authorities have a complete understanding of the full legal context in this country.
Is there a legal process or the intention of a legal process against Mr. Assange in the United States and the founders of WikiLeaks? Number two, in the event that that were the case, what type of legislation and with what conditions and under what maximum penalties would those people be subjected? And third, is there the intention to seek Mr. Assange's extradition to the United States? And the response from the United States has been that it cannot offer any guarantees. With these precedents in mind, the Ecuadorian government, loyal to its tradition to protect those who seek refuge with us and in our diplomatic missions, has decided to grant diplomatic asylum to Mr. Assange.
We're disappointed by the statement by Ecuador's foreign minister today that Ecuador has offered political asylum to Julian Assange. Under our law, with Mr. Assange having exhausted all options of appeal, the British authorities are under a binding obligation to extradite him to Sweden.
There are many irregularities in the Swedish case against him. Mr. Assange has not yet been charged with any specific offence. A previous investigation against him for what the Swedes designate as minor rape, inverted commas, was dropped by a senior prosecutor in Stockholm almost 4 months before the EAW was issued.
We must carry out that obligation, and of course we fully intend to do so. The Ecuadorian government's decision this afternoon does not change that in any way, nor does it change the current circumstances in any way. We remain committed to a diplomatic solution that allows us to carry out our obligations as a nation under the Extradition Act.
The reinstated investigation leading to the EAW saw a failure of the prosecutor to interview witnesses that could clear Mr. Assange. Independent legal opinion in England has said that the allegations against Mr. Assange would not constitute rape under English law. The complainant's lawyer in Sweden has reportedly stated that the ladies themselves cannot tell if the acts in question constituted rapes because they are not lawyers.
It's important to understand that this is not about Mr. Assange's activities at WikiLeaks or the attitude of the United States of America. He is wanted in Sweden to answer allegations of serious sexual offences. His case has been heard in our courts. Following the court decision of the 30th of May this year, he exhausted all legal options available to him in the UK to prevent his extradition to Sweden.
Now, Julian Assange blames the European arrest warrant system for the outcome of this hearing, but why shouldn't the British courts acknowledge the seriousness of this case and cooperate with Sweden?
Well, I think what Mr Assange case does is illustrates the fundamental problems with the European arrest warrant, which I've been talking about now ever since it was introduced in 2004. He's an Australian citizen they want to extradite to Sweden, but this affects every British citizen and anyone who's a guest in our country. And what it does, it removes the fundamental rights of the English courts to protect its own citizens and guests in our country, because they are simply not allowed to look at the prima facie evidence in a case like this and take it into account. It's what the lawyer called today tick-box justice. And I would now say, and I've been saying now for some time, that extradition, which is now called judicial surrender, has been reduced to a bureaucratic formality, and now I'm saying that it's actually nothing better than legalised kidnap.
It's a matter of regret that instead of continuing these discussions, they have instead decided to make today's announcement. It does not change the fundamentals of the case. We will not allow Mr Assange safe passage out of the United Kingdom, nor is there any legal basis for us to do so.
Well, my party voted against this. I wasn't an MEP then. This has been going on, since before I became an MEP. We've consistently voted against it. All the other British parties voted for it. And Monday before last in the European in the European Parliament, I tried to get an emergency debate on the European arrest warrant and is it being misused for political purposes against political dissidents, and I was refused that debate, and the person who stood up and spoke against it in the Parliament was none other than Martin Schulz, the leader of the Socialists. I was amazed that somebody as important as him would get up and argue against someone as insignificant as me, but they were so terrified of having this debate that they stopped it in its tracks, and we were not even allowed a measly half an hour to actually talk about how this arrest warrant is being used now. Not only are there no charges against him in America, there are no charges against him in Sweden. This is where our justice system is fundamentally different from continental ones, because in English law, the police have to investigate, then lay a charge, then you can be remanded in custody awaiting trial. On the continent, they have a completely different system whereby inquisitorial magistrates can ask for somebody to be detained in custody while they investigate the case. That is completely contrary to 700 years, 800 years of English law, and that's the system that we've now subjugated ourselves to. And interesting, if I can say about what's going to happen in
Just briefly, very briefly.
They are going to, well, they're going to use a very, very rarely used mechanism here to try this case in secret. So we won't even be able to hear what's being said, what the allegations are, what the charges are, and all the full evidence, because it's going to be done in a secret hearing, which is absolutely astounding.
The European arrest warrant should be suspended, and suspended with immediate effect.